Hello everyone, this is Yang Pei and I'm a BS student from Jinan Vocational University of Art China and my guidance teacher is Cao Zhaoxun. Then I'll introduce my topic called Liability Determination for AI Involvement in Healthcare. Research background. The concept of artificial intelligence was proposed by John McCarthy and the Dartmouth Conference in 1956. In the 20th century, China and other countries had already begun to explore the field of artificial intelligence. And present with the rapid development of technology, artificial intelligence is no longer limited to just one definition. We have noticed that the development of artificial intelligence has increasingly become a hot topic. Especially when artificial intelligence gradually enters the medical field, people have higher expectations for its role in this regard. When a new way of inquiring about medical conditions, artificial intelligence-based inquiry emerges and human doctors are gradually being replaced by artificial intelligence. While it brings convenience, we will also find that since artificial intelligence has only a short history in the medical field, it is impossible to timely determine the attribution of joint liability when the rights and interests of patients are damaged by artificial intelligence, thus protecting the legitimate rights and interests of patients. Research in this field is conducted to fill in the gaps in the field of medical artificial intelligence and providing ideas for future shows caused by medical artificial intelligence. Problem statement. In the field of civil law, when the medical artificial intelligence causes infringement and damages personal rights and interests during the process, who should bear the responsibility will become a hot topic for social discussion. By identifying the short liability arising from AI diagnosis errors, it also involves whether AI has the status of the civil subject. Based on previous research, it is not difficult to find that the academic community has not yet reached a unified consensus on whether artificial intelligence has the status of the civil subject. As for how to identify the short liability caused by medical artificial intelligence, no effective solution has been obtained yet. Regarding the discussion of the civil subject qualification of AI, there are generally three academic viewpoints in the academic community and present: the affirmative view, the negative view, and the compromise view. As can be seen from the meaning of the term, the affirmative view supposes the identity of AI as a civil subject. The negative view is just the opposite, and the compromise view provides a rather vague solution by combining the first two, since the determination of liability is strongly related to the status of the civil subject. The research needs to confirm this issue. Secondly, in China, some regulations have already provided a basic framework for the determination of AI short liability. Some scholars believe that the principle of liability for fault should be applied to the short liability caused by AI medical products, while others do not apply this principle. When identifying its short liability, the AI system itself should also be considered. Methodology. This research utilized the methods of literature analysis and comparison. First, the literature analysis method is used to conduct a systematic sort and analysis of the correct data, identifying key areas, framework, construction, and other information. In addition, this research pays particular attention to the application of artificial intelligence in the medical field. The discussions and viewpoints of the medical community on the essential issues related to AI medical solutions, as well as the regulations and laws regarding this during the process of literature analysis. This research will continuously sort out the summaries and achievements and exciting deficiencies of the correct research, providing favorable support for this research. Secondly, the comparison method is used to compare the legislations of different countries or regions, obtaining ideas that can be used for reference. On the basis of the comparison method, category integration can be achieved, providing first reference idea for the solution of the problem of choice caused by medical artificial intelligence. And the analysis and discussions the legal civil subject status of medical artificial intelligence from the perspectives of the exciting theoretic, affirmative theory, negative theory, and compromise theory. The affirmative theory holds that artificial intelligence can be regarded as a limited subject or the practical subject. The negative theory believes that artificial intelligence is still essentially to like property or a special object and thus does not have a qualification of a civil subject. The promise theory regarded it as a limited subject. However, considering the doctor identity of artificial intelligence and the convenience degree of heading civil disputes, the paper believes that it can be regarded as a limited subject. The main limitations of medical artificial intelligence. Correctly, artificial intelligence cannot enjoy the same civil status as natural persons. If AI is granted the qualification of an independent doctor in AI medical consultations, the consequences caused by wrong behaviors during the diagnosis process will be difficult to evaluate. Although artificial intelligence technology has achieved great progress and present and has certain learning and cognitive abilities, it still does not have independent utmost consciousness and the ability to recognize emotions. Artificial intelligence under the existing regulatory framework. Medical artificial intelligence under the existing regulatory framework. Many regulated medical deceive products and the total liability of is insufficient to bear the risk brought by artificial intelligence doctors. In addition, medical damage liability focuses more on the fault of medical staff rather than artificial intelligence. Whether medical staff or manufacturers needs to bear liability can be determined by referring to the degree of human participation in the diagnostic behavior of artificial intelligence doctors. Secondly, aboard since 2015, the international community has successfully issued drafts and regulations regarding legal issues related to artificial intelligence. The AI Act approved by the European Union in 2024 provides the basic rules for the risk supervising of artificial intelligence. Construct the rights and obligation framework of artificial intelligence doctors, clarify the doctor role of artificial intelligence doctors and their lack property in attention due to the uncertainty to artificial intelligence and the importance of legal practice. To a certain extent, a limited civil subject identity can be given with medical staff providing auxiliary decision making and hospitals and manufacturers bearing corresponding responsibility under different circumstances. Suggestions. Firstly, a registry system should be adopted when medical artificial intelligence is put into use in various hospitals. Registration with the relevant medical device regulatory authorities should indicate the source, destination, and quality inspection test results. They can effectively prevent qualified medical artificial intelligence from entering the market and causing more infringement behaviors. Secondly, when patients use AI for medical consultations, they should sign an AI medical product use agreement with the developers of medical artificial intelligence with informed consent, which should include detailed descriptions of the medical artificial intelligence system, the consultation method, and the location of rights and responsibilities. This can avoid the occurrence of false infringement behaviors, medical-related disputes, and prevent the waste of unnecessary legal resources. In addition, it should be noted that medical artificial intelligence may have errors over time during use. Therefore, medical institutions can make an agreement with developers that professionals regularly monitor an artificial intelligence system and test medical artificial intelligence products to avoid system errors leading to infringements. The medical artificial intelligence recall system in the United States can be used for reference to recall, repair, or destroy problematic artificial intelligence products. If infringements have caused by system and product problems, the court can impose legal penalties on developers based on the principle of liability for fault, and medical institutions cannot be completely exempted from liability, and the undertakers of medical risks and organizers of medical activities, medical institutions should bear possible organizational liability and certainly liability for compensation for damages. The degree of medical artificial intelligence's participation in the medical process should be divided. Medical artificial intelligence can be used for either auxiliary decision making or alternative decision making. Auxiliary decision making is subject to existing product infringement rules. For alternative decision making, it is different. If the decision made by artificial intelligence is correct, the medical staff who supervise and review the decision should bear corresponding liability for violating the duty of care with errors leading to infringements. If the medical artificial intelligence make a wrong decision at the very beginning, the developers and the users are still responsible for the infringement results. Finally, basic patient data, medical records, and other information are obtained during the AI consultations process should be uploaded to the code base in a timely manner to prevent data loss and to trace the source in time when infringements occur, so as to find the cause of infringement behaviors and facilitate the court's trial and judgment of infringement behaviors and safeguard the rights and interests of patients. Concluding, fundamentally, artificial intelligence still does not have the qualification to become a civil legal subject. Even for strong artificial intelligence, its core function is still the storage and reproduction of data. Even with relatively strong learning abilities, it still lacked an understanding of emotions and morals. However, considering the efficacy and convenience of having relevant legal practice, I believe that it should be appropriately granted a limited personality and bear center responsibilities due to the black box algorithm problem of artificial intelligence. Developers are also unable to predict the future behavior and results of artificial intelligence, and we cannot expect and answers given by medical artificial intelligence to be completely correct. Therefore, during the medical solutions activities of medical artificial intelligence, a dual model of AI diagnosis and doctor supervising and review can be implemented. This will help ensure the correctness of the judgment of medical artificial intelligence. Under the existing legal frameworks, the particularity of medical artificial intelligence leads to its ability to apply the old short liability and the medical short liability. It is necessary to update it to a certain extent to reduce the risks brought by product defects and network security. In addition, relevant foreign legislation can be used for reference to determine and strengthen the structure of the nation technical standard and industry standard system. The touches and facts of medical artificial intelligence should be clearly defined. Corresponding liability, attribution, and exemption rules should be established, and at the same time, registration and supervising should be added to effectively protect the rights and interests of patients from being infringed. To sum up, although medical artificial intelligence has already potential, there are still many limitations and changes in terms of technology legal instances. Therefore, in the process of promoting medical artificial intelligence, it is necessary to carefully consider and weigh the pros and cons. Establish a should legal system to register its behavior, so as to maximize the protection of the rights and interests of patients and maintain social stability. That's all. Thank you for reading.